This is a last will and testament containing 3 specific legacy clauses. The testator wants their estate used to care for their horses, to promote animal rights legislation, and to build a new clubhouse for the local Fincham Cricket Club. In a law exam, you are tasked with executing these instructions. Your natural instinct is to execute the testator's wishes exactly as written. Equity's instinct is to strike the document down. This tension reveals a core doctrinal paradox. A standard trust designates property to benefit a specific person. Here, the testator wants to designate property to achieve a specific purpose. If you fail to identify the correct legal rescue mechanism for these clauses, the trust collapses into a resulting trust. The assets return to the residuary estate, and the testator's final wishes die with them. This diagram illustrates the structural flaw at the heart of our problem, the beneficiary principle. Established in Morice v. Bishop of Durham, a trust is an obligation. It cannot exist without an enforcer, a beneficiary with legal standing who can enforce it. History is littered with failed purpose trusts. George Bernard Shaw left behind a trust to research and develop a 40-letter alphabet. It was struck down. The alphabet could not sue the trustees for breach of duty. Without an enforcer, a trust ceases to be a controlled obligation and becomes an uncontrollable power of disposition. The courts refuse to allow this. To rescue a purpose trust, you must navigate this specific procedural algorithm. It maps the exact pathways recognized by law to supply the missing enforcer. The first major divergence in the algorithm forces a binary choice: classify the trust as charitable or non-charitable. This flowchart provides the exact sequence of tests required to rescue a purpose trust and secure high marks in an exam setting. We start at the top branch. Testing for charitable status under the Charities Act 2011 is the most secure pathway. Here, the Crown steps in as legal enforcer. The statute demands the trust be exclusively charitable. A non-charitable motive makes the entire structure fail. This grid outlines the analysis in McGovern. Amnesty International sought charitable status for a trust to relieve the suffering of prisoners of conscience. The rule applied by the court states that seeking to alter government policy or procure changes in the law constitutes a political purpose, which is inherently non-charitable. Applying the rule, securing the release of prisoners inherently requires changing government administrative decisions. The conclusion: the trust fails. It is not exclusively charitable because political action is required. Universally praised human rights objectives fail if their execution requires legislative change. The trust must abandon this safe harbor and seek an alternative legal rescue. The final statutory requirement is affirmatively proving public benefit under Section 4 of the Charities Act. There is no longer a legal presumption of public benefit. You must adduce the evidence yourself. Consider the case of IRC v. Baddeley. The issue centered on a trust providing religious and social training facilities for residents in West Ham. The rule states that the benefit must be available to a sufficient section of the public, and the opportunity to benefit cannot be unreasonably restricted. Applying the rule, the trust limited its benefits geographically to West Ham. That restriction is legitimate. However, it further restricted access to residents who were or were likely to become Methodists. By limiting beneficiaries to a specific religious group within a geographic area, the trust created a class within a class, making the restriction fatal. Failing to prove sufficient public reach invalidates the charitable trust pathway.
The algorithm forces the trust into the precarious territory of non-charitable exceptions. Moving to the lower half of our flowchart, we examine the common law exceptions, starting with the Reed-Denley type trust. In Reed-Denley's trust deed, land was transferred to trustees to be maintained as a sports and recreation ground for a specific company's employees. The court established a critical rule. If a trust is expressed as a purpose, but an ascertainable group of individuals derives a direct, tangible benefit from that purpose, those individuals possess the locus standi to enforce the trust. Applying this logic, the employees gain a tangible benefit from using the sports ground. Because they can sue if the trustees mismanage the land, the court is provided with an enforcer, successfully bypassing the beneficiary principle. But there is a trap. These exceptions are subject to the rule against inalienability of capital. Unlike charities, Reed-Denley trusts must be explicitly limited to a maximum duration of 21 years, or the trust instrument must allow the trustees to spend all the capital on the purpose and end the trust at any time.
While Denley solves the missing enforcer problem, it traps the trust in a strict 21-year countdown. Precise drafting is required for survival. Finally, we must address gifts to unincorporated associations, local clubs, or political parties that lack the legal personality to own property in their own name. Courts rescue these gifts using the re-retcher construction. Instead of treating the gift as a purpose trust, the court interprets it as a direct accretion to the members' shared club funds to be used in accordance with their internal rules. We see the limits in Grant's will trust, where a testator attempted to leave his estate to a local branch of the Labor Party. The rule states that to satisfy the perpetuity requirement, the local members must retain the autonomy to pass a resolution, dissolve the club, and share the assets among themselves at any time. Here lies the secession trap. The local branch rules were dictated by the National Executive Committee. Because local members required national approval to act, they could not freely alienate the property, and the gift failed. A gift to an unincorporated association only survives if local members possess the ultimate autonomous power to dissolve the entity and divide the money tomorrow. Let's return to our exam problem and apply the algorithm to the testator's 3 clauses. Clause 1, caring for horses. This is classified as a trust of imperfect obligation, governed by the Pettengill exception. It fails immediately because the drafted clause lacks the mandatory 21-year perpetuity limit. Clause 2, promoting animal rights legislation. Testing this against the Charities Act, it fails the exclusivity requirement. Procuring a change in the law is a political purpose. Clause 3, building a clubhouse for the Fincham Cricket Club. We apply the re-retcher construction. This clause is valid, but only if you can demonstrate that the club's constitution allows its members to dissolve the club and claim the funds. Analyzing purpose trusts relies on a rigid, step-by-step diagnostic process. Skipping a single test guarantees legal failure. Execute your exam analysis in this exact chronological sequence. Always test statutory charity first. If that fails, test Denley. If the recipient is a club, apply the re-retcher construction. If the trust falls out of the charitable safe harbor, you must immediately apply the 21-year perpetuity rule. As we have seen, equity abhors a vacuum of obligation. In any exam, your primary job is to locate the legal enforcer. Mastering purpose trusts requires mastering the algorithm that dictates exactly where legal power and duty reside.